Respected Mr. Justice Ajay Kishan Kaul, Mr. Justice Rajesh Pendul, Mr. Justice Divakar, Mr. Justice Mishra, sister and brother judges, members from the State Legal Services Authorities, committees, Namaskar. It's a very unusual occasion in the sense that all the people are gathered, all of us are gathered to discuss in this holy city a problem with regard to access to justice, an enhancement of access to justice. The first issue which arises is, what do you mean by the term justice? Justice in one sense can be described as existence of rules that provide right to a fair and a just decision. Rules that provide equal and fair opportunity of winning against the most powerful and against the state itself. Now, in this sense, if one looks at it, justice and access to justice are intertwined and inseparable because there cannot be any justice without equal access. As Justice Hugo Black of the US Supreme Court had rightly put it, there can be no equal justice where kind of trial a man gets depends upon the amount of money he has. In fact, if one looks at what the framers of the Indian Constitution did when they enacted directory principles of the state policy, Article 21, 14, and 22A is reflected in the philosophy. These are the good norms which we have to follow when we go into the question of legal services authorities, legal aid, etc. Article 38, if one looks at, states, the state shall strive to provide the welfare of people by securing and protecting a social order in which justice, social, economic, and political shall inform all institutions of the national life. 39A of the Directive Principles states, the operation of legal system shall secure operation of legal system that promotes justice on the basis of equal opportunity, provide free legal aid to ensure that opportunities of securing justice are not denied to any citizen by reason of economic or other disabilities. Article 21 says no person shall be deprived of his life or liberty except in accordance with the procedure established by law. Now, the procedure established by law must provide the fair opportunity to that person, fair and good opportunity, equal opportunity to that person. Article 14 states that the state shall not deny to any person equality before law or equal protection of laws. So the importance is equal protection of laws. Whatever rights are secured to any citizen, be it when he is an accused or otherwise fighting a litigation, he must have equal protection of the laws. That means he must be able to secure his protection. But what is of most importance for the legal services authorities is Article 22(1). No person who is arrested shall be denied the right to consult and to be defended by a legal practitioner of his own choice. Now, the choice will be irrelevant in case he doesn't have the money to pay. So it is important that he should be given the right to consult and be defended by a legal practitioner. If one looks at the Section 12 of the Legal Services Authorities Act 1987, it provides for categories of people who are eligible to legal aid, according to which almost 80% of the entire Indian population of 1.3 or 1.4 billion citizens are eligible for seeking legal aid and assistance. The provisions have been put in place to ensure that those who cannot afford it have the legal representation in every state. Every legal services authority has been constituted to give effect to the policies and directions of the legal services authority. Now, in fact, one of the very extraordinary situations is that India's per capita lawyer ratio is far better than most of the countries in the world. But in spite of that, this problem with regard to providing free legal aid or adequate legal aid still bothers us. If one looks at the glimpse of the legal aid in India, we have 37 state legal services authorities, 676 district legal services authorities, 39 high court legal services committees, 6,361 Taluk Legal Services Committees. Now, as of 2022, almost 57,202 paralegal volunteers were trained. About 15,485 paralegal volunteers were deployed in various states in the country. 50,394 panel advocates or free legal aid service providers are enrolled. About 11,802 legal services clinics, out of which 1,119 are set up in the jails. There, we had provided about 63 lakh, we had provided free legal aid or benefit of free legal aid to about 63 lakhs, 69,643 persons in India. I like to here differentiate between reach in and reach out approach as far as legal aid is concerned. When I refer to reach in approach it is resorted to by the public when they approach us for legal aid. That is when they want us to specifically provide legal aid in specific situations. But what we have to also differentiate is reach out approach. That is when we provide legal aid on our own to the public. This can be in the form of legal awareness and literacy, but more important than that is when there is a crisis in any situation, we have to come out and reach out and provide legal aid to them. Now, if one looks at the legal aid position in India, we have about 22,321 legal literacy clubs in schools and colleges in 2021, about 3,44,026 legal awareness programs organized, wherein about 5,24,36,674 persons had attended these programs in 2022. About 5,261 radio, TV, YouTube awareness programs, and about 61,901 digital webinars were conducted in 2021. There are legal services helplines which exist, but the problem is we have to activate them, make them far more receptive, consumer and citizen friendly. As Justice Bindal had pointed out, the ease of access is a major issue which has to be tackled and dealt with. The legal aid services help desks, similar to legal aid service clinics, must be established in court complexes and jails. This is again an area which we have to focus on. We have to then move forward into this. Because till we have these legal aid help desks throughout the courts and in the jails, we will not be effectively able to reach out to the persons who desire and require the legal aid. There has been a lot of focus as far as legal aid at the trial stage and at appellate stage is concerned. The area of concern, which is a very crucial importance, is to the pre-trial stage, which can be divided into three categories: pre-arrest stage, arrest stage, and the remand stage. This is the area on which we must focus for the simple reason this is the situation where when the person is being called to the police station or he's been interrogated, there the awareness of the rights and the awareness of the rights and availability of legal aid is of significant importance. We have framed in 2018 early access rules. Those rules have to be now enforced and implemented properly to ensure that the pre-trial legal aid is made available to the needy and required persons. Pre-arrest legal aid we have now, and with the enactment of Section 41A in the CRPC, which mandates issue of notice to the accused at the pre-arrest stage, this has to be, we have to ensure that these compliances are regularly made. What is the effect and what is the need for providing legal assistance at pre-arrest stage? It has the following benefits: making the suspect feel less isolated or intimidated, safeguard their rights as per law, keeping in check on the police aggression and abuse of power, avoiding unnecessary arrests, gaining vital and time-sensitive information or evidence in suspect's defense which may not be available after a passage of time, and protecting the suspect from being subjected to wrongful self-incrimination contrary to constitutional and statutory protections. Here, I'd like to also refer to the decision in Prakash Singh versus Union of India 2006 decision, which had postulated creation of police complaint authorities. These police complaint authorities were required to go into allegations against the police, one, in cases of improper investigation, refusal to file FIRs, custodial torture, and high-handedness. We have, if one looks at how the judgment has been implemented, we have only in 8 states PCAs, state PCAs, and both state and district PCAs in about 14 states. That means 22 states are virtually following this, or partially following this. And in only 17 states, we have district PCAs. This is something we have to address and look into, and to what extent the state legal services authorities and committees can help us or come forward and protect the victims in this stage is a matter of concern which can be and should be looked into. Then at this time of the arrest stage, the prompt legal assistance at the time of arrest, assistance to understand why the arrestee has been arrested, protection against intimidation, ill treatment, and torture, assistance to explain and understand the criminal justice process, actualization of procedural rights, bail in bailable offenses at the police station itself. I have referred to in the end the decision in D.K. Basu's case. The issue which would arise and which perhaps requires consideration is, do we now at this, do we take advantage and benefit of D.K. Basu's case and require the police officer who arrests any of the accused to also inform the concerned legal services authority or the committee that such and such arrest has taken place? Does any paralegal or any person from the state legal authorities then interact and get in touch with the accused immediately thereafter to ensure that he's made aware of the consequences, reasons, as well as if he has any rights or any issues that can be dealt with? Integration to this extent may be required. Integration also may be required that all FIRs which are filed should be made available to, or should be uploaded, or should be accessible to the state legal services authorities or the committees, so that they have and they know what exactly where arrest has taken place, where the person has been detained, what time he was detained, whether he requires any legal aid or assistance. This is one aspect which may require a little detailed consideration, because there may be some other issues, technical issues or administrative issues which may come into way. The remand stage is equally very important, and efficient and effective legal representation to unrepresented arrestees is imperative. This is to ensure that unnecessary arrests are challenged, bail applications are filed timely, unnecessary remands are resisted, and police procedural rights are protected. I have got some data with regard to the early stage intervention by the legal services authorities and committees. This data pertains to the period 2019 to September 2022. This is from NALSA itself. About 11,505 suspects were provided legal assistance at the pre-arrest stage at the police station, out of which 4,246 suspects were not arrested. About 10,462 arrested were provided legal assistance at the police station prior to producing them before the court. About 1,13,614 arrestees were provided legal assistance at the remand stage, and 39,092 bail applications were filed at the remand stage, out of which 19,177 arrestees were granted bail. Now, if one looks at the figure at the legal aid which is provided at the remand stage is 1,13,614. But if one looks at the figures which are prior to that, 10,000 and 11,000, the figures are rather low. That means we have not been able to provide legal assistance at the stage, at the pre-arrest stage. This should not mean that we are adopting an adversarial relation with the investigation. Our attempt is not to curtail investigation, but it is only to ensure that the investigation and the procedure adopted by the police is in accordance with law. In fact, if the procedure and the procedure adopted by the police is in accordance with law, ultimately it helps secure conviction also. It invariably, we become suspicious sitting as judges that if the procedure adopted or some wrong things have been done at the time of investigation, there's any element of doubt which comes into our mind. The second thing which I want to point out, we have to get rid of the old psyche which said that until unless the police adopts high-handed and somewhat abusive or in the Supreme Court. In addition to this, we have formulated about 15 schemes as of 2022, which are basically help the victims. I have noted 3 important schemes which are with regard to victims of trafficking and commercial sexual exploitation, legal scheme with regard to victims of drug abuse and eradication of drug menace, schemes with regard to disaster victims, etc. Do we have the data with regard to how much we have done in these schemes will be another issue which has to be examined and gone into in depth and detail with regard to each and every scheme. Do they require modification, changes, and how to make them reach out, reach in, approach in all the schemes? Where do we require the strengthening? That has to be examined and gone into. The victim compensation scheme is spreading legal awareness in the community through panel lawyers and paralegal volunteers, particularly in vulnerable areas and groups. This will apply to all the schemes, in fact. Provide legal assistance to the victims at the time of rescue and during trial. Facilitate the accessing of district legal services authorities for award of victim compensation under Section 357A of the CRPC. Monitor and act as social auditors of existing facilities available for rehabilitation of the victims. Act as converging nodes to ensure that governmental schemes meant for marginalized actually reach them. Initiate steps to sensitize cooperation to support rehabilitation measures for the victims, including self-development and employment under corporate social responsibility. Assist with training and sensitization of stakeholders like the police, lawyers, the prosecutors, and government servants. Collaborate with the local educational institutions and civil services organizations. I'll just give you some statistics with regard to the compensation paid during the years 2021 and 2022. 8,715 victims were paid compensation, had filed compensation applications on the victim compensation scheme under Section 357A CRPC. About 8,267 applications compensations were awarded by the court orders. Out of the total compensation applications, that is about 16,982 applications received. About 15,173 were decided in that year. The figure of 221 crores, which is the total compensation awarded, is fairly substantial, but it does show that the number of applications received are rather low. That is 16,982. This figure should be, are we satisfied with this figure? It will depend upon the data with regard to where the victims were entitled to compensation, but they were not given, or they did not know about their rights under the different schemes, and therefore they could not get the compensation. The other area which is very important is the witness protection. Witnesses are eyes and ears of justice. Now we have the witness protection scheme of 2018 to ensure that the investigation and prosecution and trial of offenses is not prejudiced due to witness intimidation. Provide confidence to witnesses to depose and assist law enforcement and judicial authorities. Identify measures to safeguard the interests of witnesses and their family members. What is the nature of protection which is provided is anonymity, temporary residence in a safe house, new identity, relocation, etc. This again, we'll have to set up committees in all the state legal authorities and district legal service authorities to ascertain which are the cases in which witness protection is required, and then proceed whether we are able to give witness protection in all cases or not. If one wants to look at the witness protection, there were certain guidelines issued by the Delhi High Court in the case of Neelam Katara, but I'll skip that. You can have a look at the judgment and then understand that. The next area, which is perhaps a very important area, is mediation, which now under the Commercial Courts Act 12A, Section 12A, have to be now conducted by the legal services authorities. That's one aspect, but I have got some data with regard to the where mediation, on the figures of mediation, etc. I can skip that. But there's one area where we can explore mediation, which has been done in Delhi by collaboration between the Delhi government and the Delhi High Court, is to provide community mediation centers. This means what are the cases which go to the community mediation centers are neighborhood cases, parking, noise, nuisance, destruction of property, interpersonal, family, parent-child, parenting, child welfare, adult guardianship, restitution, divorce, maintenance, schools, special education, peer, student to students, minor complaints, corrections, commercial, consumer, merchant, small claims, workplace, bad checks, accident compensation, miscellaneous, police, citizen, minor criminal, victim offender, disabilities, cross-cultural, religious, charitable, and multi-party, etc. I can share with you one experience which I've had as a judge of the High Court, when large number of habeas corpus petitions were filed. Almost every day we'll receive 2 or 3, if not more. I did take help of the legal services committee in that case to interact with both the boy and the girl. And then after they were made at ease, then we will interact with them. So then we'll understand probably because of the age difference, sometimes they are, and our authority also, our position also, many of the time the petitioners or others, the parents also find it difficult to interact with us. So when you take help of somebody of younger age group, they're able to make them at ease and say the truth. That is extremely helpful in deciding. It also saves a lot of time which you would spend in these matters. Given the paucity of time, most of the case judges who are dealing with habeas corpus writ petitions are also dealing with pure criminal matters. There are benefits of obviously there are benefits of the community mediation, which I need not at this stage refer to, which is obvious because they're far more easier. It reduces the burden in the court. I think the decisions which are taken and settlements which take place at this stage, early stage, are far more easier, much far more, because everybody has an interest to settle the disputes. There's other area where we have to now focus is rehabilitation and reformation, which is a matter of concern. I think, again, there we'll have to get hold of the data and the particulars, how effectively we are doing this work, whether there are loopholes or there are shortcomings in this, and how do we improve that. I've given the details. I've mentioned about just the President's speech, which had highlighted the plight of the poor citizens, and also pointed out that all the people, including the ones who are in jail, they are one of us. Do not treat them just like one. They are just like us. The other area which has been highlighted, in fact, by Justice Kaul also in his judgments, is with regard to premature release. Now, if one looks at the data, the prison statistics for 2020, about 1,09,516 convicts were released from jails. And 49,386 convicts were released after completion of their conviction period. 43,033 were released on bail. Only 2,321 convicts were released prematurely. This is just 2% of, that means just 2% of the convicts were released prematurely. This is a matter of concern. Only 156 victims were released under pardon under 2021. So this area, I think we'll have to put into. We have, I can just share the figures with regard to the under trials as well as the convicted prisoners. The figures have improved a little bit, because the figures relating to 2020 showed that almost 76% of the persons in prisons are under trial, and only 23% are those who have been convicted. So this has to be also, this figure must be available to the legal services authorities to understand whether the courts, and feedback to the judges, are we being too strict, too conservative in granting bails or not. Because if the conviction rate is rather low, if we have the figures, then there's some problem with us. The premature figures, there's decision I've referred to of in criminal SLP criminal number 514 of 2021, which says there are 4 vital aspects of the process for premature release: timely identification of the eligible convicts, making applications by the eligible convicts with the help of District Legal Services Committee, timelines for application for procedure and decision for premature release of applications. If premature release of applications are rejected by the court or by the state governments, then legal aid be provided to the convicts to decide whether the said rejection should be challenged in a court or not. Then the other area again of little problem is probation. I think that's again an area which has not been properly explored and fully appreciated. I've referred to in my slide the Probation of Offenders Act and then Section 360 of CRPC. It's an area where we should come in and give full guidance as well as to the accused or the ones who are facing trial to be able to appreciate and fully take advantage of these beneficial provisions. Look, many of these things cannot be implemented. This is a huge area. Our field is rather vast. But what has to be done is selectively and carefully implementing different parts of the entire role which we have in different areas, with experimentation and also with certain amount of flexibility, ensure that we are able to fully and effectively fulfill our constitutional objective and the statutory objective. Thank you so much. I hope this conference will find some solutions, some guidance for the future. The roadmap for the future, whatever we have achieved, is one thing. In fact, let me also say, once or twice when we had interaction with judges who had come from abroad, they were very much impressed by our legal aid system. Abroad, it's very difficult for any convict to get legal aid because the taxpayers' money, they say, should not be made available for fighting litigation of a convict. And they have processes by which there's a examination, detailed examination, whether the person who's convicted should be given legal aid for appeal. One of the other things as far as trial is concerned, which is, I feel, can be looked into, is as far as heinous offenses where the punishment is more than, can be up to life imprisonment. Should we have legal aid committees going into the case files themselves and then guiding or saying, giving guiding or helping the lawyer who's conducting the proceedings before the trial court and in the appellate court? Because invariably what happens is many of the lawyers do not get the full feedback. And I must also share with you my experience as a lawyer appearing as a legal aid counsel in the High Court, which was a little bit disturbing. The accused came to me and interacted with me in the court itself. In the end, he said, "How much will I have to pay you?" I was taken aback. But that's a fact, that many of the convicts in jail do believe that you have to pay. The second thing which I noticed was that the percentage of cases being dealt with by legal aid counsels in the trial court is far lower than the percentage of cases which are being dealt with by the legal aid counsels in the High Court. The reason is this: when a person is arrested, he or facing criminal prosecution, they put in their entire stakes to get him released or get him acquitted. A lot of property, a lot of all their wealth gets spent at that stage. At times, false and wrong promises are also made. By the time the matter comes to the High Court or there is a conviction, the family members and the accused realize that possibly it's not working the way it is. So they withdraw, or their wealth is all gone and dissipated. So this In fact, let me also say the percentage of acquittal in the High Court, at least in the Delhi High Court, I saw in legal aid matters was higher than where private counsels were appearing. But private counsels were hardly appearing in about 10% matters, not more than that. So these are matters of concern. We'll have to all, there may be different problems in different states. I'm not saying what is happening in Delhi High Court will be replicated or is true for all the other high courts. This may not be true. But we'll have to go into the data, analyze the data, and then proceed forward. Thank you so much.